Let me tell you, I have been an attorney for several years, and before I stopped practicing law, I can tell you even I got aggravated talking to attorneys. I can tell you the number of times that I reached out to my attorney friends and said, hey, I got a quick question. And the next thing I know, 40 minutes later, I'm still on the phone talking. So some of you might be out there getting frustrated as well when you are reaching out to attorneys, or maybe people that you know who are attorneys, or maybe trying to find an attorney, and you're thinking in your mind that this is a quick question. It shouldn't take that long. And the next thing you know, you're either one, on the phone with the person or talking to them for about an hour, or two, they're telling you you need to come in and pay a consultation fee. And you're thinking, I don't understand. It's a quick question. Well, let me tell you why there's no quick questions when talking to an attorney. All legal matters are based on facts. Even though attorneys are familiar with the law is only interpreted based on the facts to those situations. So when you come and you're talking to an attorney, they're more interested in knowing the facts of the case, because the ability to know what facts you're telling them about gives them the ability to understand what law they need to apply to those facts. So when you just say one question, it usually opens up the door to a bunch of more questions, a bunch of additional questions, because the attorneys want to know specifically, in light of the question that you're asking, what law they need to apply, because that's going to dictate the answer they give you. And get ready, the more facts you give, the different answer you may receive. I can't tell you the number of times I've had people who've gotten upset with me because I gave them a response and they're like, but wait a minute, that's not what you just said. And I've had to explain to them, the more facts you give, the more different answers you're going to receive. For instance, if you give me a certain set of facts, I'm going to give you an answer based on those facts. But if you add some additional information to that, that may determine that I now have to take it into a different direction. Not because I'm trying to be a jerk, it's just because those additional facts change the nature of the circumstances you just explained to me. So let's say, for instance, you say, and I'm not a criminal lawyer, I didn't practice criminal law very long, so don't use this as the best example. So let's say you got a speeding ticket and you were like, I got a speeding ticket. Oh, okay, this is A, B, C, D, and E. Well, I got the ticket because my wife was in the car, she was pregnant, and her water broke, and I had to get to the hospital. Different set of facts, because you've now given me some additional information that I didn't have before that's going to give me a different response in terms of how to deal with that ticket. And for attorneys, facts tell them three very crucial things. How long, how complicated, how expensive. What? Depending on the facts you tell them, can usually give them a decent idea of, quote, how long the case may be. Because if it's something that is fairly straightforward, it may take only a few things. Like, let me give you a great example from a estate standpoint. If you had an estate where you're like, oh, my grandparent only had, it was just here in this particular county, he only had about maybe $1,000 in his checking account, and that's it. You're like, oh, no problem. And then you're like, oh, by the way, he had some property in another state. Is that going to change everything? Yeah, that's going to change everything. So as opposed to opening up a smaller or summary estate in that particular county, now they've got to take in consideration that there are assets in another county that has to be taken in consideration. Also, the length, like using that same example. Well, guess what? If it was just $1,000, going through the process in the county might be fairly quick. But now that you've indicated that there's additional property in another state, guess what? That now may make the process longer, because you've got to deal with the property, the money that's in one state, and then deal with the property that's in another state. Same thing with complications. Using the same example, if it's just one little item where your grandfather left you $1,000, or there was $1,000 that needed to be addressed, that's one thing. But now you've got property in another state, you've got to find out if that property was co-owned by him, if there were any tax liens on the property, is there any buildings or anything on the property. Now it becomes more complicated. Guess what? It's going to become more expensive for that attorney to have to resolve those issues. Just know that facts dictate the scope of the representation. So when you're going in, and let me just tell you, this is a natural inclination. When you're going in, there's a natural habit to want to kind of keep information to yourself, because you're worried that the more information you provide, the more expensive it becomes. Flip it the other way. The more information you provide, the more that attorney can make a determination of what things they can do to provide you the most effective measure of representation possible in the most cost-effective manner. A lot of times what happens is that people keep information to themselves, and then once they retain the attorney, and all of a sudden the attorney is like, oh, you didn't tell me this. Now you're in a situation where the attorney is having to tell you about where they have to adjust their services, and you're getting upset because you're like, well, that's not what you told me. You bear responsibility of that. So you have to make sure, don't look at it as, I can hold this information to myself because I don't want them to charge me. Lay it all out on the table, because this way, if they say, okay, if you do this, then I can take care of this, and this way it'll save you something, as opposed to letting that attorney get the shock and awe of finding out after the fact that there was information that you had that you just chose not to tell them.